call.
Yes.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or reading any material. Thank you.
Thank you. This is case number 24-159-370. This is Citibank versus Deborah Johnson. The matter is before the court. I have it set on for a review on today's date. Your appearance for the record, counsel. Counsel for Citibank. All right, do I have Deborah Johnson on this Zoom? The court will return to that matter shortly. The court now calls case number 24-163-450. That's Discover Bank versus Nadia Mosley. The matter is before the court, set on for a hearing on today's date. At the last hearing, there was an issue regarding a demand for arbitration. I did set the matter up for review on today's date. Your appearance for Discover Bank, please.
Yes, good morning, Your Honor. For the record, William Saloon P. 41487, appearing on behalf of Discover Bank.
All right, thank you, Mr. Saloon. Good morning to you. I'm looking now for Nadia Mosley. If you're on this Zoom, please say something at this time, Ms. Mosley.
Hello, yes, I'm here. Good morning.
All right, good morning to you as well, Ms. Mosley. Counsel, as an officer of the court, update me regarding this matter, sir.
Yes, Your Honor, I've had a chance to talk to Ms. Mosley. She indicated that she didn't file the arbitration proceeding because she sent a letter to Discover Bank requesting payment or inquiring as to whether they could pay that expense. It wasn't sent to our office. We never got notice of it. She, I think, sent it out of state to Discover Bank because she thought that was, where she was supposed to send it to.
All right, so what's the posture of this matter now as it relates to arbitration? Are you guys, ma'am, are you going to move forward in trying to set this up for arbitration? Are the parties talking about trying to resolve it? What's your posture in this matter?
Moving forward with trying to file the arbitration. The representative did let me know that I ended up sending the letter to the wrong place. I was going based off of the instructions in my cardholder agreement, and I wasn't aware that I had to send it to the representation for Discover Bank and not Discover Bank themselves.
All right, thank you, ma'am. Mr. Salam, any issues raised at this time regarding whether or not there is a time bar, or whether there's any lack of ability to forward with arbitration, counsel?
Well, I think our concern is always, you have a case where the last payment made on an account was years ago, and after we file a district court action, someone says, hey, I'd like to arbitrate. So the question is whether it's dilatory or whether it's, more, I don't know what the word for it would be, but I guess it's disappointing that a further delay has manifested itself other than the arbitration proceeding itself. However, she's a layperson, and I can appreciate she probably didn't understand that the legal representative for plaintiff has become our firm, and we need to get notice of her request. If the court is inclined to give her time to find out an answer to her inquiry, I'm okay with that. I can let our office know. They should immediately contact her and let her know whether that can happen. But if it doesn't happen, then I kind of expect arbitration, if she's going to file it, needs to be done very quickly. So I leave it up to the court to decide timing-wise what to do.
Well, it's certainly the only reason that this is an issue is because apparently there is a contractual provision that may allow for arbitration. So it's not really a court issue as such, to the extent that there's a contractual provision that allows the same. Obviously, there cannot be untoward delays when there's a matter that is pending before the court. Have the parties talked about Have the parties talked about resolving this short of arbitration? Obviously, there are expenses of arbitration, and if you could reach some meaningful agreement here, maybe you don't need to deal with issues of arbitration. Have you talked about any of that, counsel?
We have, Your Honor. I made a proposal to Ms. Mosley. Yeah, we certainly have, but I think she, and I'll let her speak for herself, but my understanding is she still wishes to pursue arbitration.
All right, very well. 30 days to perfect arbitration. If it's not perfected, then the arbitration will have been waived by virtue of the fact that it has not been perfected. The next action date in this matter will be the 15th of April. Can I do that?
April 15th?
4/15/25, and that's going to be at 9:30 a.m. 4/15/25, 9:30 a.m.
Thank you very much, Your Honor. Have a good day.
All right, good day. Good day to both sides.
Thank you.
The court now calls case number 24-170329. This is DNF Associates LLC versus Huff. The matter is before the court on the filing of a motion to dismiss. Your appearance for DNF, please.
This is attorney Ashley Nelson appearing on behalf of DNF P84103.
All right, thank you, counsel, and good morning to you. Do I have Lynette Huff on the Zoom at this time?
Yes.
All right, thank you. Good morning to you, Ms. Huff. All right, you filed a motion to dismiss in lieu of filing an answer. You put in there that you want to compel private contractual arbitration. The central issue here, it seems to me, is that you're asking that the matter be arbitrated. Is there an arbitration provision in the contract with DNF, ma'am?
Yes, it is. It's on page 6 of that card agreement.
I didn't hear the last part of what you said. Say that again.
Yeah, it's on page 6 of the card agreement that I attached with the motion.
All right, thank you, ma'am. Counsel?
So Your Honor, plaintiff has not received a copy of Ms. Huff's motion. So I have not had an opportunity to review it and then subsequently to review the arbitration provision to see whether or not it's applicable in this case.
Everything, I sent them everything certified mail, Your Honor.
I didn't come back to you. Thank you. All right, looking at the arbitration that's attached to the motion, it seems to provide that either party, that arbitration may be elected by any party with respect to the claim, even if there's already initiated lawsuit with respect to the claim. So it seems that at least the document that was submitted to the court has that provision contained therein. Counsel, you have any reason to believe that such a provision would not be applicable under these circumstances?
At this time, I do not, Your Honor.
All right. So what I'm going to do is, given that Ms. Huff has indicated that she wishes to proceed by way of arbitration, she has to initiate an arbitration proceeding in order to do that. And the court, given that the arbitration provision allows for an action to be maintained while the arbitration is going forward, this case would not be dismissed under those circumstances. I will set the matter for review in 45 days. The arbitration must be perfected within that time. Otherwise, the case will proceed according to the standard practices of this court. So, Ms. Huff, you will have to set up your arbitration pursuant to the contract within the next 45 days. I'm setting a hearing in this matter. That hearing is going to be on the 30th of April. That's 4/30/25 at 9:30 a.m. And arbitration must be completed on and before that date. Otherwise, the matter will proceed. All right, I wish both sides well. Good day to you.
I thank you.
All right, this is case number 12-11-9003. This is First Community LLC versus Eddie Golden Jr. The matter is before the court on the following objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter. That judgment amount, just one moment, is $4,382.48. That judgment was entered on April the 23rd of 2013. That judgment was renewed subsequent to that time for the same amount. Just one moment. And the renewal date was the 20th, strike that, November 9th, 2022. All right, your appearance for First Community, please.
Yes, it's Timothy Baxter. My bar number is B28045.
All right, thank you, Mr. Baxter. Good morning to you, sir. I'm looking for Eddie Golden at this time. Say something if you're there, sir.
Yes, I'm here, Your Honor.
All right, thank you, Mr. Golden. Mr. Golden, I looked at your objection to the writ of garnishment. You said I had not received no notice before the garnishment. What are you talking about, sir?
No, so they said they was trying to contact me, sending me letters off for the court for the first court date of the matter. They say never found me or whatever, and then when I started working or whatever, and years after that, they finally caught up with me or whatever, as far as the payments, and just started taking out payments. I just felt like if I had a court date, you know, equal, even equivalent court date or whatever to plead, you know, some type of payment, not payment arrangements, but some type of settlement or something to that nature or whatever. But I didn't get a fair trial to get that done or whatever, and now I'm just getting garnished every week.
All right, so there's no unfairness that occurred anywhere. This case was brought against you back in 2012. A judgment was ultimately entered when you were not, when you did not respond. Alternate service was allowed, meaning that when they could not reach you, the court entered a special order allowing the documents to be mailed to your best known address, and that on that basis, the judgment was entered. So this judgment has been in place for more than 10 years now. As it relates to the issue of trying to resolve it, and the issue of whether or not you can object to the garnishment based upon something that happened previously in the case, you can't really do that. The garnishment is a post-judgment matter. Any issues that you have with the judgment, that's pre-judgment. So you can only deal with post-judgment matters. That's why the form says things like the funds are exempt, or you file for bankruptcy or something like that, or you have a payment plan. It sounds like what you're asking me today, you're asking me to give you some type of payment plan so that you are not dealing with the garnishment. That sounds like what you're really asking about. Am I on the right track with that or what?
Yes, sir, Your Honor, you're correct.
All right, Mr. Baxter, any thoughts at this time before I go further?
Yes, Your Honor. The defendant has told us that he's working 7 days a week. I really think this is the best time to do a garnishment because he's probably the defendant.
I don't work 7 days.
I have to stop you because you can't talk until I give you the opportunity to talk. Okay. Just like this gentleman could not interrupt you, I won't let you interrupt him. He's going to finish. I'll come back to you, Mr. Golden, in just a moment. All right, go right ahead, Mr. Baxter.
I think that the defendant is probably making more money today than he's ever made before. And I think this is a great time to pay off the judgment. It's 12 years later. We have not received a penny other than the garnishment wages. And we've received a total of $960.51. That's about 20% of the judgment. I would ask that the court deny the objections because they are not legally valid and allow the garnishment to go through. Thank you.
All right, let me ask you, Mr. Baxter, before I go back up. You received, you told me about the amounts you received. I believe you said 960 or so. Do you know what the garnishment rate is? Is that one pay period, or does that reflect more than one pay period? Do you know?
that reflects more than one pay period. It reflects the payments that we've received since the date that the garnishment was served on the employer back in October.
Okay, so, and then the second thing I need to know is, having applied those payments, what is the balance on the judgment at this time?
Well, the original judgment was $4,382.48. We've received a total of $916.51. So the current balance is $3,702.11.
All right, and so I was looking to see whether there was any interest applied to this, but it's 33702.11, correct?
Correct.
All right. All right, Mr. Golden, go ahead and unmute yourself so that you can talk to me, sir. So how much is being taken out your check per week, sir, for this garnishment?
Okay, Your Honor. So when the attorney started taking the garnishments, I was working 7 days a week because the plant was on overflow.
Stop you.
So
Let me stop you. Simple question. Okay, I'm not trying to give you a hard time. There are a lot of people. It's a simple question. How much money being taken out of your pay when you get paid? Give me a range. They take $200 a week or $150, between $30 and $200. Tell me something. That's what I need to know.
Okay, Your Honor. So they've been taking $255, $266. And according to how many days I work, it'd be one something, because I don't work 7 days a week. I work 7 days a week as needed, but the plant has been shut down, so it's been slow production. I've been working 3 days a week, some days no week. So,
okay. Got you. And I know you want to tell me about you not working 7 days. You work 7 days every time you get a chance to. That's neither the issue for him or for the attorney on the other side. None of that is really the issue. The issue here is you got this judgment that you got to get this judgment paid off. So I'm not going to move the garnishment because I don't have a basis to do that. I can adjust it. So what do you get paid? Every week or every 2 weeks?
I get paid every week, Your Honor, and I'm working 5 days a week, Monday through Friday, and weekends as needed, and not no weekends been needed in the last 3 weeks.
Talk about that again, because you work 7 days whenever you get your hands on 7 days. I'm convinced of that. So
yes, for sure.
I already told you that we don't need to talk about that. I don't care if you work 7 days. I don't care if you work 15 hours a day. I mean, the bottom line here is that you're trying to get some relief from this, and that makes sense to me. But let's figure out how we might go about doing that. You got $3,702 that's owed now. It may be less than that. The gentleman said that they received $916 since October. How much money has been taken from you in total? Do you know?
It's probably about that much.
About that much? Okay. Because sometimes there's some money taken out that has not been transferred yet or applied yet. So you may have a lower balance. And you said you get paid every week, correct?
Yes.
Okay. All right. So what I'm going to do is I'm going to leave the garnishment in place, but I'm going to adjust the garnishment to $100 a week, up to $100 a week, and $400 a month to get this satisfied. The garnishment will stay in place, but my order will adjust it to up to $100 per week during the pendency of this matter, and hopefully that will help you get it resolved, sir. All right, that is my order. I do wish both sides well. Good day to you.
Thank you, Your Honor.
All right, I have Counsel for Citibank? Do I have counsel for Citibank? Do I have? This is case number 05-136-053. Excuse me, this is Midland Funding versus Timothy Williams. The matter is before the court on the filing of objections to a writ of garnishment registered flag. A judgment was entered in this matter on the 15th of December of 2005. That judgment was renewed on October 13th of 2015. There seems to be an outstanding balance, and this is an attempt to collect on that balance. Your appearance for the plaintiff, Midland, please. Looking for
Yes,
Midland.
yes, Your Honor.
All right, is that the attorney for Midland talking?
No, this is Timothy Williams, sir.
Ask for Timothy Williams, yeah.
Oh, I'm sorry, Your Honor.
The attorney is here. And everybody, it's important for you to listen because there is a certain process that has to follow. The attorneys come on the record first and I have to find out whether or not they're here or not. All right. Now, Mr. Williams, it doesn't seem that the attorney is here on the other side. You filed an objection indicating you says it's not me. This judgment's been in place for well over 10 years. What are you talking about?
Your Honor, Your Honor, I don't even know what the bill is from. I called them. Nobody can tell me when I came down to 36th District. The guy just told me who it was from. I don't even know what this bill is from. I've never received anything. The only reason why I found out was because I received something in the mail for my state taxes this year. That's the only way that I found out that this was against me.
All right, well, this judgment has been filed against your state taxes for 2019, 2020, 2021. Garnishments have been filed against your state tax for 22, 23. So this has been around for a long time, and garnishments have been filed against you for a significant period of time. So I don't get that this is your first time hearing about this because the record seems to suggest something different than that. Now, do I have counsel for Midland?
Judge, what attorney's office is that? I have a Midland, but not this one.
Okay. Mary Jane Elliott.
Oh, then I can handle it, Judge. I'm here for their office today. I just didn't have this one on my list.
All right, well, your appearance with regard to this matter, please.
Navjot Francis, P72322, on behalf of Plaintiff's Attorney of Record, Your Honor.
All right, this is an old judgment from 2005. Mr. Williams is on the Zoom. It's regarding his state income taxes. He indicates that this is the first time that he's hearing anything about this is when he got the notice from the Michigan Department of Treasury. He says he didn't know anything about this. Talk to me as much as you know.
Judge, I would just reiterate what you've already said, that we have done multiple previous garnishments. So this can't be the first time he's heard about it. Either way, his arguments that attacking the underlying judgment would not be a valid objection to a tax garnishment. And it's kind of a little too late to attack the underlying judgment through any motions, since I'm not sure what exactly he's filed today.
Well, he filed objection. His objection says that if the writ was not properly issued or is otherwise invalid, he says it's not me.
Okay, then I would argue that's not a valid objection to the garnishment, Your Honor, and his objection should be denied.
Yeah, under the rules, I mean, it would not be a valid objection. I'm trying to figure out why, as you argued that this would be something that you've not heard about, when the file seems to show that there have been objections, excuse me, that there have been garnishments filed over and over against your state income tax return. And the judgment has been renewed. You didn't respond to the complaint back in 2005. I just don't see anything there. I mean, it's now what you can always do. You heard me say a little bit earlier how that there is challenges before the judgment is entered and then challenges after the judgment is entered. So those are called pre-judgment matters versus post-judgment matters. When you file an objection to a writ of garnishment, you can only deal with post-judgment. And this post-judgment basically is that the funds are exempt. I already have an installment plan, things along those lines. Pre-judgment stuff is like, I'm filing a motion to set the judgment aside, things like that. But that's not, you've not presented to me anything that I could take into consideration to set this garnishment aside, because there's a judgment. And that judgment has been in place since 2005. Again, as I said, it was renewed in 2015. So I don't see a valid objection to the garnishment. If you come up with something else more concrete that you'd like to file, either trying to attack the judgment or otherwise, you can always file again. I just don't see anything today that I could address on this. So at this point, the objections to the writ of garnishment are found to be invalid because I don't see any basis for the same. And I'm signing an order consistent therewith. I wish the parties well in this regard.
Can I ask a question, Your Honor?
Yeah, very quickly. I have other cases. Go ahead, sir.
Okay, so how do I go about, because I explained this to the lady and this is what she told me to do. So how do I go about, this is not me? I don't even know what the bill is from.
To answer your question, I can't give you legal advice. The second thing is that you probably haven't been able to do much of anything about it because it's been so long ago. But I can't tell you not to find a way to fight on. You can speak with a lawyer. They will tell you something about trying to file a motion to set that judgment aside from about 15 years ago, 20 years ago now. The other thing is that you're coming up on October, I believe it is this year, where you'll have this 20-year period and the statute of limitations will likely run at that time. So you got a lot of issues going on. But again, I can't give you legal advice. I'm a judge. And the person at the counter that directed you to the form, they weren't giving you legal advice either. You told them you had a garnishment. Of course, they will tell you that the garnishment objection form. That's not legal advice. You have to figure this out. And I'm not saying that that's the easy thing to do. You're not a lawyer. I understand that. But nobody can tell you which way to go with this. You have to kind of think through and figure this out yourself or talk with a lawyer, because that's how this stuff works, okay? All right, I wish you well, sir. Good day to you. All right, this is case number 06-101-951. Excuse me. Unfortunately, the air is not the best air in here sometimes, so I talk a little bit in the air that circulate some days in here as well as it goes. All right, 06-101-951 Midland funding versus Lucretia Montgomery. The matter is before the court on the filing of objections to a writ of garnishment. Your appearance for Midland, please.
Judge, again, could you tell me what law firm that's for?
Mary Jane Elliott.
Oh, okay. I can handle Navjot Francis on behalf of plaintiffs Attorney of Record.
Thank you, counsel. Do I have Lucretia Montgomery on this phone, please? I see someone there. Are you say something at this time, ma'am? You got to unmute yourself. If you hit star 6, that should. Star 6 should get you
Okay.
off.
Can you hear me now?
Yes, good morning to you, Ms. Montgomery.
Good morning.
All right,
How are you?
I am good. I looked at your objection to the writ of garnishment regarding the Michigan Department of Treasury. And you point out that the letter was received on February the 19th, issued back then in 2020, and then it was never resolved. What are you trying to tell me, ma'am? Talk to me.
Okay, so I received a garnishment letter from them. I never heard of these people before, but the thing of it is they are trying to garnish my mom, which her name is Anastasia Montgomery, but somehow they got a hold to my social security number and they have been garnishing my checks since 2006. And they was trying to take my state taxes this year. And I filed an objection because it's not me. It's my mom who they're trying to garnish. But it's my social security number.
All right, ma'am. So you're Lucretia Montgomery, correct?
Yes, sir.
All right, counsel?
Judge, I would argue if Miss Lucretia Montgomery is the defendant's name on the case, then she is a proper defendant. Again, she's trying to attack the underlying judgment, which is not allowed through an objection to a tax garnishment.
Well, the register of action now looking at counsel only has an Anastasia Montgomery. It does not have Lucretia Montgomery.
And they didn't spell her name right.
Didn't ask you anything yet, did I?
Oh, no, sir. I'm sorry, Judge.
No, that's all right. Let me ask you something now, since you ready to talk this morning. You say you've been garnished for several years and it's not you?
Yes, sir. I went down to 36th District Court and they gave me these papers.
Okay,
And
I
it said,
stop. I'm wondering why you garnished you all those years if it's not you.
I don't, like I say, the papers say it's Anastasia Montgomery, not Lucretia Montgomery, and they have my social security number.
By the way, I like the name Lucretia. That's my sister-in-law has a beautiful name as well. Here's what I'm asking you, ma'am. You said you were garnished for several years. You've been paying through garnishment?
Yes, I mean, when I went, listen, I'm not familiar with it, sir. Like I say, I went to 36th District Court and they gave me these papers. And, like I was saying, it got their name and stuff on it, but it's for my mom. And I see where they took all this money, but it was coming from me working over the years that they was taking money from my checks. I guess from my,
Why didn't you file something to stop the garnishment? That's what I want to figure out because
so we had the same issue in 2020 and me and my mom called them in 2020 and we thought they resolved it then, but clearly it didn't get resolved because when I called them.
Let me ask you this. So in 2020, when you talked about it, the garnishment stopped in 2020?
So I never received my state taxes up until last year. That was the first time I ever received my taxes, but I never looked into it because, I just never did because I work. So, I'm like, I would always wonder will my state tax.
Okay, I had to cut you off there. Okay, I had to put you on mute because you're not answering my question. You got to answer my question. Okay, and my question was, you said something about a garnishment that was stopped in 2020, and you said that they stopped the garnishment in 2020. Is that true? Is that what happened? Say yes or no. If you don't know, just say I don't know.
Oh, I don't know. I don't know, sir. I don't know, Judge. I don't know.
Thank you. Ms. Francis, are you able to access any records to see what's going on here?
Judge, I am not at this very moment. If I could ask for an adjournment so we can look into this.
Wow.
Maybe just 1 week, since I don't have this file in front of me, Judge. I don't think we got notices on these hearings.
It certainly, I see Ms. Montgomery shaking her head. And the other thing is to leave the garnishment, in place and not do any further hearings. It sounds like you raised a reasonable objection that needs to be investigated. Is that what you'd like to have?
I think it's a tax garnishment. If she hasn't filed her taxes yet, then Judge, I don't think there's any harm in adjourning it for a week.
Yeah, I think I need more information. I know you raised your hand. You raised your hand because you agree that the judge needs more information, don't you?
Yeah, so they hold my taxes right now. This third party company called, the state or whatever. They hold my I had filed my taxes February the 28th. And they hold my state taxes right now for $3,219. They were supposed to release it to them on the 19th of March, which is this month. But I filed an objection so they wouldn't get it, because it's not, like I say, it's my mom. It's not me. It's my social security number. They trying to take my state taxes and they still got a hold on it right now.
So with the information I have right now, I would allow the garnishment to go through because I don't have enough information. So you think it makes sense for me to adjourn this for a week so that they can give me some more information? That makes sense to you? Ms. Montgomery?
No, I don't know. It don't make sense to me because it's not me who they looking for. It's my mom.
Yeah,
It's just got my social.
Okay, well, you didn't file anything. You didn't file anything with any validations or anything to show me any of that. I'm just not sure. I'm trying my hardest to help you, but it seems like you ain't getting it. Now, if I sign this thing denying the garnishment, they're gonna get your money. If I adjourn it for a week, they got to come back and show me that they got the right person. That makes sense to you?
Okay, yeah. Yes, sir.
All right. You trying to make me lose the rest of my hair.
No, I just don't. I'm just trying to understand everything. That's all. I'm sorry.
Let's see if we can get some more information, okay, ma'am? Because
Okay.
you interesting point. That usually doesn't happen. But somehow it seems that you're saying that your social security number is connected to this file. We need to investigate that and see what's going on. So give them a week and they have to come back. You have to come back on next Wednesday as well, so that we can talk about this and figure out what's going on. Better yet, I'd like to put it on Thursday next week, so that I'm Wednesday. I have a lot of these kind of cases. So next Thursday, the 20th. So that's when you're going to come back into the Zoom, and Ms. Francis is going to investigate this. You bring any information with you that you may have, and let me dig into this and see what's going on. And to the extent that you're right, we may be able to get you some relief from this. That's what right? All right. I wish you well. I'll see you on next Thursday.
Sorry. What time, Judge? Sorry.
What'd you say, Ms. Francis? I didn't hear you, ma'am.
Sorry, what time, Judge, on the 20th?
9:30 on the 20th of March.
Thank you.
All right, I'll take another look at it at that time. All right. Good luck to both sides.
Thank you, Judge. Judge, if you have the next one as Midland also, could you pass it for a moment? Another judge is just calling me.
What other case do you have, Ms. Francis?
I have 707 and then 648. And then I'm not sure if you have any other for Mary Jane Elliott's office.
All right. Just one moment here. This is This is 17-101-707 Midland versus Montgomery, Stanford. That is before the court on the filing of objections to a motion for partial payments, actually. Looks like there is also the filing of an objection to a writ of garnishment. Counsel, your appearance on that matter?
Not Jack Francis, on behalf of plaintiffs, turn your record.
All right, thank you. Do I have Montgomery Stanford on this record? Stanford? Are you anywhere on this Zoom? I'm looking for Montgomery Stanford. Sanford, Sanford, living on Evergreen Street. Camry, last name Stanford. All right, the defendant indicated that by way of the objection that they did not receive notice of a court date, then filed a petition for installment payments, and the petition did not set forth any amount that they're asking the court to set as an installment in this matter. For that reason, the objections to the writ of garnishment would be found to be invalid, as it seems to attack the underlying judgment in this matter. Moreover, the petition for installment payments would be denied because there was no amount requested as an installment payment. That petition would then have to be denied.
Thank you, Judge.
Right.
Did you have any other Midland cases, Judge? I can hang on to in case you do come up with some.
Well, I'm looking for the other one you said that you have. What's the last four digits of the one you say you had?
The last four are 1648. If it's okay, could I just go on record with my other case? The judge is just waiting for me. I'm sorry.
Case number 10-111-648, Modern Financial Corporation versus Maryland Cox. The matter is before the court regarding the filing of objections to a writ of garnishment. Your appearance, counsel.
Najat Francis on behalf of Plaintiff's Attorney of Record, P72322.
All right, thank you, Ms. Francis. And do I have Marilyn Potts on this Zoom? Say something if you're here.
I'm here.
All right, good morning to you, Ms. Potts. I've looked at your objections to the writ of garnishment. You indicated that you never served, you're disabled, the account family reunion, dispersed, event, et cetera, et cetera. Tell me what you're talking about, because none of that seems to be a valid objection to the writ of garnishment. If you believe that the judgment should not have been entered many years ago, you'd have to file a motion to try and get that set aside. But it doesn't seem like you have a valid objection to the garnishment. Talk to me.
It's not my bank account. It's my family reunion bank account. I was one of the members of the family reunion meeting. So I had a bank account at Bank of America. We opened a bank account, me and my cousin, Lamont Baker. I have some information. He has an itemized list of people who deposited money. They went to the bank and it's not my bank account. My name was on it. Me and my cousin opened it with funds from other people, not my funds at all. I went to the bank. I had a bank account there, and for some reason, my debit card didn't work. So I went to Bank of America to withdraw $100 out. They took it out of my family reunion bank account. I had to replace that. So I don't know why they went into the bank account that's not mine.
If your name is on it, you're one of the owners of that account, and you have a judgment against you, so that they can properly proceed in that way, ma'am. Let me hear from Ms. Francis. I'll come back to you, Ms. Francis.
Judge, I would argue the same thing. I had a hard time reading what she wrote with her objection, but if her name is on the account, then she is an owner of the account and an owner of the funds. So plaintiff is entitled to garnish the bank account and retain those funds to go towards her debt that she owes.
Yeah,
but it's not.
Yeah, but you're one of the owners of the account, ma'am. If you have a judgment against you, that's one of the problems that come up in these situations. If you have a judgment against you, you have your name on an account. You're one of the owners of that account.
Well, I'm really able to make a payment arrangement if they had contacted me. 2010 is when it started. I was working then, even though I was retired at that time. I was 62, so I retired early. That's not my bank account. I'm only a person who's responsible for writing down the payments, keeping things up to date. I have a list of people who deposited money in the account. $500 was my cousin had to pay because.
Let me stop you for a minute. I know that that's what you like to tell me because you told me that twice already. You don't have to.
It's true.
Okay, well, I'll sit back and let you talk and I'll listen to you. Or you could listen to me and understand that if you have your name on that bank account, that you're one of the owners of that bank account. And legally, that's your money in that account. Legally, that's the problem. Now, I don't disagree with you and disbelieve that you are managing stuff for the family reunion. But unless you have that set up in a trust account, unless you have it set up in a trust account, then that's your account. If you have another person's name on there, that's your account and that other person. That's the problem. And because it's your account, they have the right to garnish the account. Otherwise, they couldn't garnish it. That's the problem, man. So if you tell me about other people put their money in there, or all of those things, that's not going to matter much here because it's your account. Go ahead, Miss Potts.
So I'm retired. I have another bank account that I get my Social Security from, and that's on the account. So why didn't I get any notice? Or I can make a payment agreement. I can pay a little money. I have a little money that I can dispose of. I don't understand why it's other people's responsibility to pay my debt. My cousin.
Ma'am, let me stop. It's not other people's responsibility to pay your debt. The reason that your account with your Social Security did not get interrupted because Social Security is uncollectible. They can't collect out of that account. If you have an account that has your name on it, you're the owner of that account, the money that comes into that account, you own that account. That's why this garnishment is coming against your account. It's okay if you disagree with that. That's a law. That's legally permissible. But it's not legally permissible for them to garnish your Social Security account, so they can't do that. And I understand that you like to make to set up some type of partial payment arrangement. I don't have any legal basis to disallow the garnishment on this account because it's an account that is owned by you. The last thing you get to say, ma'am, I'll make my determination. Go ahead.
I don't think it's owned by me if it's not my money. It's not my money. I have my cousin, he's an accountant. He used to work for an insurance company. So and I never really did anything. I just was opening the bank because it needed 2 people. And I live in Detroit and the family reunion was in Toledo and he lives in Las Vegas. So I understand. Is it any way possible I can make a payment agreement so my family is not responsible for $2,000? It started at $998, and that's 2010. And every address that they have is not my address. I never lived there. The address, the bank. How come the bank couldn't tell me this self? I found out my cousin sent me an email from Las Vegas, February the 14th, Valentine's Day. That's when I first knew that $2,000. I went straight to the bank to protest. I just want to know, why is my family responsible? And when I can pay, I'm responsible. I want to pay.
All right, thank you very much. Anything else, Ms. Francis?
No, Judge, I believe this garnishment will actually pay off this judgment. So if the objections are denied, we will file a satisfaction of judgment.
All right,
what does that mean?
The court has listened to the arguments on the objection to the writ of garnishment. The objections that addresses that the judgment should not have been entered because there was not service or something 10 years ago, however long it's been. Those issues are not before this court. I can't address those pursuant to the court. But secondly, the issue raised relative to the notion that the petitioner's family is paying for her judgment. If she likes to think of it that way, that's okay. That's however she want to think of it is however she want to think of it. The fact of the matter is that she owns an account. And it's unfortunate that she says that there is an accountant in her family that has knowledge of these things, that they would not advise her along those lines to give her information that if you open an account and you have a judgment against you, then that account can be attacked unless that account contains money that is your Social Security money, because these are not Social Security funds. These are funds that are under the control of Ms. Potts. And because they're under the control of Ms. Potts, it can be garnished because she has an outstanding judgment. And that's an unfortunate reality, but it is a reality. And I don't see a valid objection to the same. For that reason, the objections to the writ of garnishment will be found to be invalid, and any funds withheld will be released to the plaintiff in this matter. The plaintiff has indicated that they will release a satisfaction of judgment, meaning that they'll release a document saying that the judgment is paid off upon receiving the funds from the bank. That is my determination. I wish both sides well. Good day to both sides. No, ma'am, I've heard everything I need to hear. I'm done with that case.
Thank you, Judge. And then just to confirm, you didn't have any other Mary Jane Elliott cases?
I'm not sure, ma'am. I'm moving on to this case.
Okay, thank you, Judge.
Judge, may I speak?
Ma'am,
Judge,
you've spoken 4 times. You've spoken 4 times, and I'm going on to another case. If you disagree with me, you can always appeal me, ma'am. You're obviously not going to hear anything I tell you about it because, and that's what all with the highest degree of respect. I feel that you're in an unfortunate situation, but the unfortunate situation is occasioned by the fact that you are not aware that if you open a bank account and your name is on it and those are not protected funds, that those funds are going to belong to whoever garnishes that account. That's the situation that you're in. That's unfortunate. If the other side is not willing to stipulate to set it aside, then I don't have any basis to set it aside. So if they were willing to stipulate to set it aside, then they could set up a payment plan. That's not what they're willing to do. They're not willing to do that. So I'm done with your case. I've got to move on to other matters at this time. This is case number 21-152797. This is Mimic Insurance Company versus Ashley Russell. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter on the 25th of June of 2021 for $12,168.25. Your appearance for Mimic, please. For Mimic, Ashley Russell, if you're on this Zoom, say something.
Hi, good morning.
All right, to you, Ms. Russell, just one moment now. Thank you for your patience in this regard. All right, so you indicated that you have an installment plan in place paying on this judgment, and that therefore you are objecting to the garnishment, correct? Is that correct, Ms. Russell?
Yes, that's correct.
So, Ms. Russell, the first thing is that the fact that you have an installment plan does not prevent a non-periodic garnishment. This is a non-periodic garnishment with the state that can still be done even if you have a partial payment plan. And then the second thing is that in review of my file, I see that your installment plan was set aside because you didn't keep the agreement. There was an order signed recently setting that installment payment plan alone because you didn't keep up with the payments on it. So you got 2 problems on this. You didn't keep the payment plan, number 1, and then number 2, the law is filing for that. All right, anything else you wish to tell me this time?
Well, yes. So I was told when they filed the set aside, I was told that once I became current, that it would be dismissed. So I am currently current with the payment. Only reason I fell off is because I was on FMLA from work, and I tried to call them and explain it to them, but they said that basically they didn't care about it. So I am fully caught up. I am not late on those payments. And I was told with them that once I caught up on the payments that the order would be set aside. I didn't know that, or else I would have filed an order against that to set it aside. I wasn't. It would have been going one time.
All right, ma'am. So I can tell you what the file makes very clear, and that is that order has been set aside for the installment payments. And so you would have to, unless the plaintiff submits some document to the court saying that they are stipulating to reinstating the order. Otherwise, the order is set aside at this time. You can also file a petition for restatement or for an installment plan. But at this time, that installment order is in place. But I wanted you to understand that even if it was in place, that does not prevent the garnishment of the income tax return. And that's the issue that we're dealing with today, is that that's not a valid objection. Just, you know, they can garnish your wages and also bank accounts and tax returns and things like that. The prevention of I should say a wage garnishment generally would prevent any further garnishment of other wages and what have. But it doesn't prevent the garnishment of the income tax, the Michigan State income tax return. So, Ms. Russell, for that reason, I would have to find that the objections are invalid, and that the funds that are withheld at the state level, they will be able to receive those funds and apply it towards the judgment. And again, if you want to get that partial payment order reinstated, because the next thing would be the garnishment of the wages, and I would not like to see that happen. You got to get a partial payment order reinstated or file a petition for a new one, because right now that order has been set aside. All right, I do wish you well, Ms. Russell. Good day to you. Council, Mr. Ross Overley, and I see a couple of council in here. I don't know why. I'm going through a lot of stuff and I'm not seeing your cases come up. Let me try and work at that. Mr. Slauson, I'm going to come to you as well. Sir, what case do you have?
Good morning, Judge. This is John Butler, P33908, on behalf of Chief Financial Credit Union. Your case number, last four, 2815. It's an objection to a state tax garn.
All right. This is case number 23162-815. This is Chief Financial Credit Union versus Adrian Ishmael. The matter is before the court on the founding of objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter. That was by default on the 22nd of March of 2024 for $14,256.57. All right, your appearance formally on this matter, counsel.
Yes, good morning, Judge. John Butler, P33908, on behalf of the plaintiff.
Thank you, counsel. Good morning to you. Thank you for your patience. I'm looking now for Mr. Strickland for Adrian Ishmael. Adrian Ishmael.
Yes, it's she.
All right. Good morning to you, Ms. Ishmael. I've looked for your objection in this matter, and you are objecting to the state income tax garnishment because you indicate that you have a partial payment order with the court. Is that correct, ma'am?
That's correct. Also, because you know, they charge. I mean, the amount is different than what I. It's not 14,000. It's only like 10,000 or something.
Right. So we'll get to what the balance might be regarding this. And counsel, oh yeah, I do see where there's an installment order for $225 per month that was initiated just recently.
Yes.
Regarding this garnishment, counsel, you may at this time, sir, your response.
Well, Judge, I don't believe that a garnishment seeking a tax refund would be. I believe it's invalid when there's only an installment payment order. I believe it prevents wage or personal service garnishment while that order is entered. And Judge, just as to the balance as of today is $12,095.75. I would indicate that the amount on the state tax garn was prior to starting to receive some payments on this matter.
I didn't understand the last part, if you will, sir. You said the amount,
At the time of the filing of the state tax garnishment, the amount we were seeking was correct. There have been some credits since that time because some payments have been received. The balance today is $12,095.75.
and you have not received the state garnishment at all. That's not reduced, that's not deducted or anything from the amount, correct?
You are correct, Judge. We have not even received a disclosure to my knowledge.
All right, so Ms. Ishmael, I do have the document establishing that there is a payment order in place. That does not prevent the non-periodic garnishments, such as a garnishment of the state income tax return or bank account type garnishments. So it doesn't prevent that. And the council has provided information his office has showing that there's a balance of $12,951. There may be some outstanding payments that have not been applied yet. That's the amount that we work with for any outstanding amount. And that would have something to do with judgment accruing on the interest accruing on the judgment. Go ahead, ma'am.
Yes. As far as the balance being 12,000, that's wrong as well. The last payment that they received from my job, I get sub pay. I'm not working. I get sub pay now, and the sub pay is like $1,636 a month. And they had I got watered this judgment on the 29th of January. So they received $204 on the 31st of January. They received $204 on the 14th, as well as on the 28th. And so that month alone, last month, and then I paid the $225, which is the judgment. So last month alone, they had received $600 and something from me, $635 or something like that from me, as well as this month, March the 7th, they received $377. So the only reason why I went down there to file this again is because I'm like, it took them so long to stop stop taking the money out. Because the first time I got the papers, I sent it off to my job and stuff, and then they said that number 5 wasn't marked, stating that about the installment. And then they went down there. Then they said it needed a stamp. It wasn't a stamp on it. So I had to go down there several times to get this done. So they at this time they still receiving all this money. Now, right now, but the last payment they received was $377 and some odd cents, and they received that this month. And so I'm like, okay, by them receiving that, do I still have to pay the $225? And with the $377, that came up to like $10,997. When I paid the $225, it made it come down like $10,700 or something. I seen my last statement from my job, and that was the $10,900. But they received the 225 was not added to the 10,000. So when I deducted the 225, that what brought it down to 10,700 and something. Let
me stop you now.
10,755, I think.
Okay. Here's what I want you to understand. I'm going to order an accounting. That means that the other side, Chief Financial Federal Credit Union is going to send you a document showing what the judgment is, what amounts they've received, and how they've been applied, and whether or not there's been any interest that is accrued on any of those, any of the judgment amount. And when you receive that document, it should show payments that have been made on there. And if there are payments that have not been reflected on that document, then you'll want to file an objection, and the court will review it at that time. So I'm going to 30 days to do that, because it sounds like some payments came out or were made in the month of March. A lot of times there's a delay from the time that you make the payment to the time that the payment is applied. So 30 days from now, we have a better picture of what payments have been made and what payments have been applied. And so they'll send you that email, and then you go over it, And if you find objections to it, then put your objections in writing. As it relates to the issue that's before the court today, and that's whether or not they can garnish your state income tax return, even if there is an installment order in place. And the law does allow them to do that. So I would have to find that that objection is valid, and that they would have the right to receive the income tax return, even if they are receiving an installment order, payments under an installment order, unless there's a written agreement to the contrary. I don't see where there is a written agreement to the contrary. Right, that is my determination in this matter. I wish both parties well. Part of the order is that the plaintiff must submit to the defendant and send a copy to the court of the accounting of this matter within the next 30 days. So,
can I say something?
Judge, may I quickly just indicate there is interest on the face of the judgment that was entered by the court. So I'm not sure she's starting with the right balance. I'll send her a copy of the judgment also.
Right, and you would show that calculation and what the judgment said. That's what I already mentioned to Ms. Ishmael. That is a judgment that's bearing interest. So there's interest on it. That's going to make the amount not go down as quickly because of interest calculation. But she's entitled to an accounting that shows how that's. So in 30 days, you're going to send that to her and make sure that she receives it. All right,
thank you, Your Honor.
As I move on,
Hello? Can I say something?
Yeah, ma'am.
Yes. So by them receiving all this money, and plus I still had the $600 last month, and my judgment, my installment thing was only for $225.
Hey, stop. You already told me all of that. Okay, I don't need to hear that again. If you're asking me, do you still have to make your installment payment? Yes. Otherwise, you get bumped off of the installment agreement.
This month? Because even though they got paid to $377?
Want to ask me that 6 more times? I'm not trying to be cruel to you, but now you know I heard your question. I'm giving you your answer. You want to go ahead and make your installment payment nonetheless, ma'am. And I looked through the file and I noted that that on your installment order there was not under paragraph number 5 an indication of when the garnishment was ended, when the garnishment was entered. And for that reason, that's why the garnishment kept going on. I don't know why that happened. I know that one of the things that happened is that I tried to assist you in some kind of way the last time you were in front of me by giving you an installment order to try and stop the garnishment. Somehow, by doing that, the information did not populate to that form as to when that garnishment was issued, and I'm not sure why that happened. But suffice it to say, has the garnishment been stopped now?
Excuse me?
Has the garnishment been stopped?
I don't know yet until I get my check.
Okay, well, it should be, and I will send you something to try and make sure you get that resolved, because I know how important that is. And it wasn't on the form. And if it's not on that form, then they won't stop it. But you said that you had got some information to change that, right?
Yeah, I had to come back down there and they put it right. They marked the number 5, and then I had to go back down there again because they had no stamp on it.
Yeah, you already told me that. I heard everything you said. Yeah. I'm looking at the form. That information was not inserted, and the reason that information was not inserted is because when I gave you an installment order on the day that you came on your objection to the garnishment, I didn't have that information, so I didn't put it in there. But you came down and got the information that should stop the garnishment. But you need to stay on the payment plan. If you miss that payment, you can get bumped off the plan. That's the whole point of that.
Right.
I wish you well, ma'am.
Thank you, Judge.
Yep. All right, this is case number 22197291. Counsel, Mr. Slauson, which one are you on, sir?
Your Honor, good morning. I am here on JGA Acquisitions Inc. versus Willie Ryes.
All right, yeah, that's the one I'm calling now. That's again 22197291. JGA Acquisitions Incorporated versus Willie Ryes. The matter is before the court on the following of objections to a writ of garnishment. Your appearance for the record at this time, please.
Thank you, Your Honor. Christopher Sosson, spelled Sossong, P59383, appearing on behalf of the plaintiff.
All right, and do I have on this Zoom Willie Ryes, please? If you're on the Zoom, please say something at this time.
I'm here, Your Honor.
All right, thank you, Mr. Ryes, and good morning to you. I looked at your objection. You said, I've never done business with the plaintiffs. That's not a valid objection to a writ of garnishment. That's an objection that you raised when the complaint is filed against you. This judgment was entered back in 2023. So that's really not a valid objection. So anything else you wanted to bring to my attention in this regard, sir?
So I just received this garnishment letter from my employer. That's how I found out about it. And far as saying about not ever doing business with them, I've been a victim of identity theft in the past, and I had to file a identity theft report with the FTC, Warren Police Department, and I also submitted a complaint with the Attorney General's office.
And have you filed that information with JGA Acquisitions?
No, not yet. All this is just new to me. Like we just
but what happened, what it seems like this came from was there is the allegations that you rented, that you some property on the window at Warren Maynard Associates back in 2016. And this case arises from JGA Acquisitions purchasing the debt from Warren Maynard Associates and sued you based upon those items. So that's the genesis of the debt. And the second thing that happens here is that I received a proof of service regarding this matter that indicated that you were served on the 13th of December of 2022, that you were served at an address on East State Fair in the city of Detroit. And that, again, the date that I indicated to you. All right, so that's how this case gets to where it got to. All right, it started out with something to do with Warren Maynard Associates that was purchased by, a debt purchased by JGA Acquisitions, and then they brought suit against you. That's why this is where it is right now. All right, let me counsel regarding this, and then I'll come back to you and see.
Thank you, Your Honor. Plaintiff concurs with the court's assessment. The specific basis as raised in the objection to the garnishment, I have never done business with the plaintiff. It is an attack on the underlying validity of the entry of the judgment itself, which is expressly prohibited by MCR 3.101 K1. And so the defendant fails accordingly to state any valid basis for his objection. An objection is not a proper procedural mechanism by which to attack the validity of the judgment. If the defendant does have facts to contend that that he's not liable for the debt that was sought in the complaint, the defendant certainly has a mechanism available to him to seek redress with the court, but that is not through an objection, and for that reason, since the basis for his objection is again expressly prohibited by MCR 3.101 K1, plaintiff would respectfully request that the court deny his objection as invalid. Thank you.
Yeah, that's a long and short way, Mr. Ryes, of saying that procedurally you can't do it this way, even if this is something that you believe to be identity theft. You'd have to do that by attacking the underlying case. You can't really do that garnishment. So, anything else you wanted to bring to my attention at this time?
That's it. That's it.
All right, so Mr. Ryes, have you been on your job? Have they garnished? Have they taken any money yet?
Yes, I just started.
All right, and how much is your garnished amount? How much did they take?
This pay period, it was like $122.
122. 122.
Yes,
And so you get paid every other week or every week?
every other week.
So your garnishment is about 242 a month. So 242. All right. Well, you certainly the judgment in this matter is 2,300 or so, and I don't see a valid objection to the writ of garnishment. What type of obligations do you have? Because otherwise, I leave it in place at 244 a month. Right?
I'm the sole breadwinner, father of 8, married, and I'm pay child support.
How many kids live with you? You said I'm a father of 6. I thought I was bad.
It's 4 that live with me.
All right, counsel, anything at this time?
Yes, Your Honor. I would just add, the garnishee did file a disclosure, and in the disclosure that was filed by the garnishee Bright Pledge Carriers LLC, the garnishee does disclose that there are 2 higher priority writs or orders currently in place, and those are listed in the disclosure, and those are two writs in Wayne County in case number 912-371-062, as well as case number 913-002-918. I suspect those may be child support writs that the defendant is referencing to. So those writs would of course retain priority. And I would just note those writs may also reduce. I know the defendant's been garnished at this point, but with those 2 writs in place and being higher priority, they may further reduce what amount is being withheld in the future, beyond what he's just said right now, that there may be no withholdings at all. I just wanted to add that.
Those are important points because the child support stuff is always going to take a higher priority, and it could reduce what could be taken out of that. It also points out, of course, that Mr. Ryes is under significant constraints. So, sir, what I'm going to do is I'm going to reduce the amount that can be taken to up to $75 per pay period. So that'll put you at $150 a month, and that will save you some of the money that normally be taken out. Yeah, you got a lot going on. It's not a whole lot of other things that can be done, but I will leave the garnishment in place. But it will be up to $75 per pay, and you'll get an order from me in that regard. And make sure you take it to payroll. I think we'll send it to the location in Saline as well, and they'll know that for this garnishment they can only take up to $75.
Okay.
I wish you also. Okay, to you. Thank you, counsel.
Nothing further for plaintiff. Thank you, Your Honor.
Okay.
Thank you very much. You as well.
All right, this is case number 24146307, Discover Bank versus Candace Bishop. The matter is before the court regarding objections to a writ of garnishment as well as a motion for installment payments. Do I have Discover Bank? Anyone from Discover Bank on this matter? Do I have Candace Bishop? Candace Bishop.
Good morning, yes.
All right, thank you, Ms. Bishop. Good morning to you, ma'am. I've looked at your objection to the writ of garnishment. You indicated that you're not employed. That's not a valid objection to a garnishment, and this seems like this is a bank account. Is that correct?
Yes.
All right. How much money is in the bank account?
Probably like $50 now at this point.
So what was in there when they garnished it? Was there was $50 in, right?
No, yeah. I mean, they weren't able to get anything because I guess it wasn't enough in there.
Right.
I've been off work. I had 2 major neck surgeries, and the job I had, when I don't work, I don't get paid, and I still have to maintain my part of the insurance through my job. And I was trying to keep up. Everything just was overwhelming, and I had to stop working to get this together, my health together, so I can go back to work. I had no intentions on not paying them, but I'm listening to you talk to everyone else, and I understand what you're saying now. So, I just really don't know.
Well, as it relates to the garnishment, I don't see any basis for the objection there. And the good thing, I guess, for you is that there's not any money there. You know, otherwise they would have been able to take whatever the funds were in that account. So, I mean, that is what it is in that regard. Then you filed the petition for installment payments. You know, when you're asking to pay $25 a month on a $3,800 judgment, I can't set the payment at $25. Can't do that. What type of income do you have, or how are you getting paid? Are they able to garnish your income? I guess is what I'm getting at.
I don't have an income at all. My brother moved in with me before I stopped working, and he's on disability for lung cancer, and we're just really living off of that, which is not even, well, I mean, just at $1,000. So I'm just really struggling at this point.
Okay,
I worked my job for 14 years, so I don't have any income coming in.
I guess what I'm saying is that you, the money that's received in the household, that's not income to you, is it? That's income to your brother or something?
Right. Yes, it's his income that's taking care of us now.
Yeah. So, I mean, you really don't have a way. You really don't have any garnished wages that they could garnish. I mean, kind of what you do is at the point that you start receiving income, that's basically when you would file for some type of petition for installment payments. Because at $25 a month, I can't reasonably set up a payment plan for $25 a month on a judgment at the amount that is judgment. So I'd be glad to give you an installment plan, but the first thing that you should do is just when you get back to work, when you know you're going back to work. And then you probably, under this type of judgment, you probably could get something that maybe $100. You don't need to file for
I'm
that.
sorry. I'm sorry. I missed the last part. You said I could, when I get back to work.
Yeah, you probably could get a partial payment at like $100 a month. So you don't need to be filing for that until you get back to the place where you maybe can have some income. Because right now they can't garnish your wages because you don't have any wages. See what I'm saying?
You're right, but they want to garnish my account. And the only thing that really I'm worried about is the only time money is going into my account is when the rent is due, where I'm transferring it from one place to put there to pay my rent. And I just didn't want them to take that. But
they will take that, ma'am. So
I know.
You have to figure that out, because if you have an account and you put any money in that account, because you have a judgment, they'll be able to take that money. You see what I'm saying? Now, if you
Yes, sir.
if you get if you get an installment order in place, and you have work, oftentimes they will not go after other things when they have a regular payment. So right now, I think that what you have to do is you have to wait until you're in a position to make a payment or to set up an installment. And I don't think unless you have, if there's anywhere that you have some income coming in, that's a little bit different.
Yes.
Because if you have income coming in, they find that and they garnish the wages on that. Otherwise, otherwise, there's nothing you can do about the bank account. You can't stop the bank account garnishment because they have a judgment. So you really can't stop it. So you have to, I guess you'd have to find some way to pay your rent without using a bank account. That's what I'm saying. Otherwise,
yes,
they're gonna garnish.
Okay, thank you, Your Honor. Thanks for your time.
All right, so I can't enter the $25. I'll be glad to come back, file your paperwork whenever you see that you're getting in a position to earn some money, and I'll be glad to give you a partial payment. I just said,
okay, you sound a little muffled to me. When I get a job, you say.
That's probably more me than you, ma'am. I've been talking a little bit, so let me speak up a little bit. I said it's probably more reasonable for you to file the petition for a partial payment once you have income coming in, because then you could put an amount down there that's like 75 or 100 a month, and then I could sign something like that. If your judgment was like $500, I could sign a $25 partial payment. But with your judgment being the amount that it is, I can't sign a $25 payment. See what I'm saying?
Yes, I understand.
All right.
Okay.
So
I appreciate your time.
I'll deny the petition at this time, but I will. I'll anticipate that at the appropriate time you'll file one, and then I'll address it at that time. Okay.
I will.
How is your neck doing, ma'am?
Not well at all. So I'm just really frustrated by the time.
I know that. Are you dealing with any fusions and things like that now?
I'm sorry?
Are you dealing with any cervical fusions?
Yes, I had two. I had two, C3 through C6, and it's just moving down, and like my left arm and hand is just numb now. It's not very useful, so I'm just really trying to,
So are you in therapy now?
Well, we stopped now because we're trying to decide if it's even worth to do a third surgery. I mean, you only have 7 discs in your neck.
Right.
So, yeah. Well, when I get back to work, because I know I'll be going back to work. I love my job. I love what I do. And I intend to go back to work. And I will just come back down and try to get some assistance in. I really do appreciate the court's time. I have a better understanding now.
Yeah, I wanted you to have that, and I wish you well. I've had a neck surgery in the past, man. I understand what you're going through, the numbness and all that crazy stuff. So I
had 2 years in a row, Your Honor. Like 2 years in a row. That's a lot. That's a lot. That really made me struggle. It just slowed everything down for me. I was always good with my credit and my bills, and I never had this problem before. So just a little frustrated, and but so is life. People get better, I'm sure.
Step at a time, ma'am. Step at a time. And you make sure that when you're ready, come back and we'll take a look at everything, okay?
I will. I appreciate you, Judge. I appreciate your time.
All right, all the best to you.
Thank you.
All right, do I have Deborah Johnson on the Zoom? Deborah Johnson. This is 24-159-370 Citibank versus Deborah Johnson. I called this matter previously. does appear that I had it set up for review. Neither party has appeared regarding this matter. And clerk, I think I'm gonna reset it for another day, okay? So, all right, this is case number. It looks like I have another.
Yeah, for a subpoena, you have 056 Sims.
No, I'm telling you, I have two Deborah Johnson files right now. Oh,
Deborah Johnson.
that should be. That's the paperwork out. Okay, got it. Thank you. All right, this is case number 2414-3056. This is Alfreda Sims versus Steve White. The matter is before the court on the regarding an issuance of a subpoena. I noted that the parties were in a breakout room. It looked like they got stuck there, so I.
No, we're here. I'm here.
Yeah. I haven't asked you anything yet. I was still talking.
Oh, sorry.
There you go. All right. They were stuck in the breakout room, and so I pushed the buttons to get them into the courtroom, is what I was saying. All right. Now, do I have Alfreda Sims on this Zoom?
Yes.
Good morning to you, and thank you for your patience. I know it's been a long morning. Do I have Steve White on this Zoom?
Yes, you do.
Thank you, Mr. White. Good morning to you as well, sir. So you're here on this subpoena regarding money owed regarding the judgment that was entered for by consent for $2,000. So what's happening, Ms. Sims? Update me. Tell me what's going on.
So we was in the break room. How you doing, Judge Coleman? So we was in a break room. So Mr. Steve White agreed to pay me $200 March the 21st. And he was paying that for February and March. And then every month on the 13th, he would pay me $200 a month till the bill is paid off.
Mr. White, is that what you agreed to do, sir?
Yes, sir.
All right. So I had something set up with you guys way back there in June of 24. It was $100 a month or something, right?
Yes.
Right.
All right. So starting March, what's that date again? In March, he's gonna make a payment?
March the 21st or $200. That's for February and March. And then he started making his payments every month, $200 until the bill is paid off.
No, $100.
Oh, you said 100?
Yeah, I start making my payments of $100 until the bill is paid off. If I have, okay.
Okay, so you're gonna catch up. You're gonna catch up in March with a $200 payment. That'll cover February and March. And then in April, you're gonna make a $100 payment and continue your payments until you get it all satisfied, right?
Yes, sir.
And that's your understanding as well, Ms. Sims?
Yes.
Okay. All right, so what I'm going to do, I want you guys to get this done. You've been working at it, and I'm glad to hear that. So I'm gonna set a date of April the 7th for you to come back in front of me just for review. I want to make sure things are going well. Well, not April the 7th, I should say. I'm looking at May the 7th. So that give it a chance for the March payment to be made, April payment to be made, and then May the 7th, they'll come back and talk to me. If they have problems, then you can raise it at that time.
You say May the 7th?
Yep, May 7th at 45.
Okay.
I'm hopeful that you all will just get it all taken care of, but if you got any problems or anything, come in on May the 7th and we'll talk about it and figure out what's going on.
Okay.
Now, if everything is going swell, then we don't have to call in?
Exactly right. Okay? Don't even bother to come in. Okay?
Okay.
All right. Okay, thank
you. Thank you. Have a good day.
All right. Yeah.
Okay, bye-bye.
Is this the one that's coming back? Stanford.
No. To next week, that was the lady for the, I took her file. Yeah, that was late.
What did I do?
That was the Anastasia.
Oh, yeah, exactly. Okay. All right, this is case number 2424-1539. This is James Hogan versus Marquita London. The matter is before the court on a claim of appeal from the magistrate hearing in the small claims division of this court. Today is the time set for the hearing on this matter, a noble hearing in front of this court. All right, do I have James Hogan's second on this Zoom?
Yes, Your Honor.
All right, thank you, Mr. Hogan's, and good morning to you. Do I have Marquita London on this Zoom?
Yes, Your Honor. Good morning.
All right, thank you, Ms. London, and good morning to you. All right, and this is a claim of appeal. The appeal is heard de novo, meaning that the court hears the matter as if it's not been heard before and make a determination as to whether or not, as to what the outcome of this matter should be. I'm looking at the complaint in this matter filed by Mr. Hogan's, and this complaint has to do with a claim for $4,200. The document says engagement ring, legal fees, defendant kept and refused to return the engagement ring after the relationship ended, fees to prepare a prenup that was requested by the defendant. All right, so let me have the parties raise your right hand and be sworn at this time, please. You do solemnly swear or affirm that the testimony that you're about to give in the matter that's now before the court is the truth, nothing but the truth, so help you God.
I do.
I do.
Thank you. Mr. Hogan, this is your complaint, and as such, you have a burden of proof, and you get the opportunity to go forward first to tell me what this case is about. After you presented your side of the claim, Ms. London will have an opportunity to her side. I will weigh what the two of you say and make a decision as to what the outcome of this case is. Whatever decision I make is final. It is not appealable to any other court. All right, so Mr. Hogan's, tell me about this. You were engaged, looks like you say this claim arose in April of 2024. You were engaged to Miss London, is that correct?
That is correct.
All right, and at some point you broke off the engagement, or somehow the engagement broke off, or is that true?
That is true.
So you, as a result of the engagement, you provided a ring as a part of that, is that correct?
Yes, sir.
All right, and how much did you pay for the ring that you provided?
The ring was $2,300.
All right, and I know that you said the claim arose in April. So tell me a little bit about what happened. How long did you date? When did you make the engagement, and when was it broken off? As best as you can tell us.
We met approximately, oh my goodness, I have to think back now, about August of, it was in the fall of 2023.
All right.
And it went quick, Your Honor. I proposed in mid-December, and it ended beginning of April.
So you proposed December 2023, and then April of 2024 is when things had ended, correct?
Yes.
So did you ever receive the ring back?
She returned the ring at the last hearing.
So why are you here now?
Because the magistrate he refused my reimbursement for the filing of the prenup. Miss London required a prenup in order for us to move forward, and so I retained a lawyer, and those fees of $2,000 and some odd dollars were paid as a retainer for that documentation to be prepared. And she countered, and he awarded on her counter that I had to repay a gift that she gave me.
So what do you talk to me about what you're asking me to do?
I just want to we can just call it moot, and we just go our separate ways. If I wanted you to review the validity of the judgment on the counter, because she gifted me $1,000, and he required that I pay that back. I was working a lot of overtime, and after I got off of work, I would go to work on a property that I had. And so Miss London wanted me to spend time with her. We were supposed to go on she was trying to set up for some time together. And I told her, well, I can't do it right now. I'm working. I work so many hours overtime a day, and then I go and work on this house. So she said, okay, if I cover your overtime for 2 weeks, can we go away and we do our thing together? So I agreed to that, and so she gifted me the difference of 2 weeks for 2 hours of overtime. She said she'll give me that so that I could concentrate on fixing the house, and that would free me up to spend time with her.
All right, and so let me ask you about this. Well, let me ask you, General. Did you guys spend money on each other during the relationship?
All the time.
In relationship to the this prenup agreement, tell me about that, sir.
She required. She wanted to make sure that she had some property that she wanted to go to certain members of her family that she did not want me to have access to. And so I have the draft here that she sent me.
So let me ask you this: the prenup would protect you and her, correct?
Correct.
How much money did you spend acquiring the prenup, sir?
It was 2,000 and one second, Your Honor. $2,400.
All right, and was that for legal fees?
Yes, sir.
Do you have a date upon which that was prepared? You said you had a document. What date? What date is it?
Okay, here it is. Here it is, right here, sir. It is the date that I signed this. This is 12/28 of 23.
Anything further you wish to tell me at this time, sir?
One second, sir. Let me verify this amount, please. Because they have it itemized here. It was payment to client trust 2,500, withdrawal. They have it itemized, sir. Would I be able to give you the figures?
Yeah, well, let me ask you, in regard to the itemization of the billing for this service, does all of the items apply to the prenup agreement?
Yes, sir.
So you weren't, in other words, you weren't hiring these attorneys for some other service in addition to the prenup. All of these were prenup fees, correct?
These were all prenup fees. Yes, sir.
All right. And who was the attorney or the firm that prepared the document?
Bowyer and Midgard, PC.
What's that first name again? Give it to me.
Bowyer and Midgard, Midtgard, PC.
All right. Anything further you wish to tell me in this regard?
Did you want the amounts or no?
You told me it was $2,500.
No. That was the withdrawal, but that was the draw from the trust account. I had to give them 25, but they gave me some back at the end. They gave me so really it's 25 minus 8. They gave me back 890. So the difference between 25 and 890 is what they actually used.
All right, got it. All right, thank you. Just one moment. All right, thank you. Anything else, sir?
No, not at this moment, no.
All right, thank you very much. All right, Miss London, correct that the two of you met sometime in 2023, got engaged in December, and broke it off sometime at around April of 2024. Is that those statements about the size about correct?
Yes, he broke it off in April 2024. I was in agreement that he did. Yes, that's correct.
Last part, you said he broke it off and you were.
Yes, he broke it off in an email on April the 2nd of 2024.
So it's been brought to my attention that one part of this, the parties have already acted upon and resolved, and that is, of course, the ring is a gift in anticipation of marriage, and that ring would certainly have to be returned. So it seems like you already got that part worked out.
Yes.
Go ahead and tell me what you wish to tell me about this matter.
I was going to tell you the ring. I did try to give him. I didn't receive my my servants until December, 2 days before my birthday. But I tried to give him rings from the course of April into December, and on 7 occasions, which I showed the magistrate, and he just refused to take it back from me. And I was not going to mail it because I thought I might end up in court just because I learned him. And the $1,000 was not a gift, Your Honor. I am not in the business of giving man gifts, and I cannot afford to give gifts, but we did buy each other things. And this actually was cash money. And it is not true that I was going to pay him not to go to work. That doesn't make sense. It was an advance because he was supposed to either sell or rent this property, which he ended up selling it in July of 17 for like $130. And he was supposed to either add that to the marital part or pay me back. But it definitely was not a gift. There have been numerous things that we bought each other, but this particular thing was not a gift, it was a loan. And also at this point, as of today in the first hearing, I'm also seeking, hopefully you would let me have my lost wages because I've missed 2 days, which for me totals about $1,846 because of what I do. And also my prenup was also done with a lawyer, but I was also smart enough not to pay them in advance. So I don't think I should have to pay for a prenup that never got filed or went through with. I just severed ties with my attorney and I didn't pay her anything.
All right, ma'am. So tell me a little bit more about this. Let me ask you this, man. What did the two of you do, or you, or both of you together? What did you do to distinguish the $1,000 from any other?
So, as I showed the magistrate judge, that was the only. Are you talking to him?
Don't start talking until you see my lips stop moving. Okay. What did you do to distinguish the $1,000 from the activities that occurred between the parties, financially or otherwise, during the approximate year or so of relationship? Go ahead, man.
It was the biggest difference is I actually went to the ATM for this loan that I gave him, didn't give to him, that I advanced him. Every other thing we've ever purchased, he would purchase it his way. And I like to purchase things on one particular card because I get a lot of points. So this is the biggest distinguishment that I was able to show the judge, because my anticipation was to get it back. Otherwise, for what he's saying is for was he was trying to fix a floor and sell the house. We would have otherwise just purchased those on the credit cards like we typically would. So this was definitely an advance and not a gift. We have given each other things with higher value, but this was literally an advance for what he wanted to do, to sell or rent. And even the plane tickets that I'm not asking for, that was something that I took the loss on because we didn't spend that trip because he ended the relationship. But that $1,000 was definitely cash money. I have the ATM withdrawal, and he knew that because that was our verbal agreement. I'm not going to say unintelligent, but I would never give somebody $1,000 just to give it to them as a gift, not to go to work. That doesn't make sense at all, Your Honor.
All right, ma'am. And let me ask you about the all right, just one more question. So as it relates to the prenup agreement, ma'am, is it correct that that agreement was going to benefit you as well as Mr. Hogan?
Yes, it was a mutual to get a prenup. It wasn't just me. It was a mutual decision to get one. We both had separate attorneys, and I guess he had a retainer, and I didn't use a retainer that required me to advance her in a retainer before the document was produced. And I never seen the document either, Your Honor. I'm sorry. I've never seen the documents he's referring to.
All right, anything else, ma'am?
My lost wages, please, because I've missed 2 days and approximately 26 people have suffered because I've missed 2 days, because unfortunately I'm unable to take off hours. I have to take off days.
Unfortunately, that's not convincible at all under no circumstances. Thank you.
Is it a way to convince?
I feel you, but that this is not convincing. It's just not.
Why? I was going to ask you, I'm sorry. I mean, I was like, is it not convincing because of the amount, or you just said I can't have lost wages?
You can't have lost wages. Not in this. You gotta come. You could elect not to come to court, and then it has its consequences. If you elect to come to court, that's something totally different. It's just there's just not a way to cover that. And moreover, you have to be the party prevailing in order to cover anything, even though. Right, let me go back, Mr. Hogan. You said you had something that you wanted to say, sir.
Yes, sir. Just a quick visual. This is the itemized from the lawyer.
Only thing that worse than you today, man, is that visual that you're trying to show me.
This is the itemized invoice from the lawyer. I'm sorry, sir.
I got you. You already told me about that. Okay. Anything else?
Yes, sir. As far as her to say that the prenup was a mutual agreement, Miss London made it perfectly clear. She is far from fragile. She is far from unintelligent, sir. She made it clear that the only way she would go forward with the marriage was if a prenup was entered. So I capitulated. For her to claim that she was paying me not to go to work, this was overtime. I worked as much overtime as I could get my hands on. And this was one of the contentions in our relationship. She was like, "You at work again? When you gonna leave? When you gonna leave? Why you always at work?" And so that was when she offered for me not to do the overtime, to focus on the house, get the house done. She said, "How long would it take you?" I said, "About 2 weeks." So she said, "Okay, well, I'll pay 2 hours of what overtime will be valued at for 2 weeks if you focus on that house so that we can do ABC." I was like, okay. That was the extent of the what was discussed about that. There was never any "you gonna pay me back" or "it is part of the marital pot." Or we discussed and wrote down everything. I have notebooks, I have texts of different meetings we had where in detail she would go over what was important to her and I would go over what was important to me. This was never mentioned until after I broke it off, and in her response to my complaint to return the ring and the cost of preparing the documents. That was the first time this was ever mentioned.
All right, sir. Anything else?
No.
All right. So given that there is a complaint and counter complaint, Miss Lundy, you get a chance to speak once more, and then the final word is with Mr. Hogan.
Thank you, Your Honor. I just wanted you to take into account, if you can, that I'm not trying to be funny or anything, because I am a physician, so it cost me more to come to court than it would have for what he was saying. So it just doesn't make sense logically. I'm not lying to you. I don't have a reason to lie. It definitely wasn't long. And the ring was returned to him after I had all the documentation I showed, tried to make him take the ring. I didn't feel comfortable mailing it or leaving it with his parents because they are forgetful. So I was trying to get him to get it personally because I thought he would sue me based on just knowing him and the emails I received. But I promise you I can show the debit. It was definitely not a gift. I'm not in the business of gifting man money. And this has cost me more to be here this 2 days and prepare the paperwork than it would have even been worth. But I don't understand why he's trying to get me for a prenup that we both mutually agreed to do, and he just happened to do a retainer for his. I'm not understanding, but I thank you for your time.
All right, and we certainly respect everybody's time. I have a sister that's a physician as well, so I know how expensive the time can be. Of course, it's not compensable here. Of course, if you were subpoenaed to be in court in some case that involved the medical profession, you really can't do it on this kind of personal matter. All right, and sir, you get the last word regarding this matter.
Yes. I mean, part of it has been resolved, the returning of the ring. I refer to your judgment on the prenup issue, and the funds were a gift because Miss Marquita wanted to spend some time together, and I was working on my goals that I was trying to reach, and so that was her way of trying to help me satisfy my goals and have her wishes met also. That's it.
All right, thank you. The court has listened to the testimony that's been offered by the parties. In regard to that testimony, the plaintiff has the burden of proving his claim before the court by a preponderance of the evidence, meaning that he has to ponderate and offer evidence, more evidence to support the proposition than evidence that is against the proposition. If my hands were evenly without shaking before the court, to preponderate means to tilt the scale. And oftentimes people hear about proof beyond a reasonable doubt, and that usually relates to a scale like that. Preponderate means that you gotta tilt the scale in favor of the proposition that you're raising before the court. With regard to the claim that was brought as it relates to the ring, that's a rather easy one because of the way the law is on that issue, because the law says a gift in anticipation of marriage has to be returned, because obviously the gift was given in anticipation of marriage. But the plaintiff has the proposition of proving his claims by honors of the evidence, any claims that he raises. Also, the defendant has the responsibility of proving her claim by a preponderance of the evidence, or to preponderate, to show, tilt the scale in favor of the proposition raised before the court. As it relates to the claim regarding the prenup agreement, obviously the prenup agreement was one that was beneficial to both parties that was involved here. The prenup agreement that was drafted, being prepared, was one made in anticipation of marriage, and it was at the request, the desire and the demand of both parties that was involved in this. It's overwhelming evidence to support that proposition, notwithstanding the fact that Ms. London said that she was going to have a lawyer to draw up a document on her behalf as well, and spend no money doing so. Fortunately, she did not, because if she spent money doing that, then what the court would have to do is take the gross amount that the parties spent and split it between the two of them. So if she had spent $2,000, he spent $2,000, it would be $4,000. And the strange thing about it is that they end up half and half. They end up being the same way. In this case, the net amount paid for a prenup agreement, unfortunately or fortunately, whatever, the parties never use it, was $1,610. $805 is the collective or joint share that the parties have in that regard. And then my finding would be for the plaintiff in that regard that he is entitled to recovery of the $805 as a part of the drafting of a prenup agreement. And finally, on the counterclaim, where there is a claim for $1,000 and an indication that the $1,000 was an amount that was separate and apart from the other things that the parties did in the relationship. In a relationship, I don't have to tell these parties, they are wise enough to know that people do things for each other for the benefit of the relationship. It is what it is. They exchange, they give money for this, they do money for that, whatever. I heard a couple of times by the counter plaintiff in this matter that I don't give men money and what have you. Wow, I'm glad that my wife now and my late wife do feel that way. But it is what it is. I know that these are difficult times. I know that people have challenges in a number of different ways. The problem is, or the concern here, is whether or not this particular one can be distinguished from the other things that were done throughout the relationship. And that's the issue, the distinguishing between something else and this in the relationship, because that's what raises an issue of preponderation, or whether or not the parties end up in the same place. Well, as I look at this, and I have to say that I vacillate on this issue because I have to think about it. I have to think about what this really means. What it seems to me is that this stands out as something different for both parties. While they disagree as to what the impact should be, it stands out differently. I don't hear the parties talking so much about other things that occurred. I did hear something about flights that have been purchased in anticipation of a trip, so on and so forth. But this stands out as something different. The suggestion that a person who was engaged to someone could not give them money, I don't get that part because it happens. But this seems to be on Mr. Hogan's part. Yeah, I got some money to take off of work. Ms. London says, well, I gave him some money, anticipating that I'm gonna get that money back. None of the other stuff that the parties did has that type of sense to it. And so it raises an interesting kind of conundrum as to whether or not this is something over and above and has some distinction from the things that the parties normally did. And while it is a very close call for me, it seems that there is enough here to distinguish whatever happened with that $1,000. Am I 100% comfortable with that? Well, I don't have to be, because this is not proof beyond a reasonable doubt. It seems that that this issue is an issue where something different was going on between the parties, and Ms. London has a reasonable expectation that the $1,000 would be returned in that regard. My determination is that the plaintiff is entitled to $805 as reimbursement, partial reimbursement regarding the prenup agreement. The defendant counterclaimant is entitled to $1,000 in regard to the $1,000 that was transmitted to Mr. Hogan. In the end, I don't know how much difference it makes to the parties, but it sounds like net on this comes out to about $195. So it would seem that Ms. London owes Mr. Hogan about $195, and the return of the ring is already done. That is my determination.
Do I owe him, or does he owe me, Your Honor? I'm sorry.
Thank you. Thank you, Ms. London. He would owe the counterclaim $125. Let me get my head clear on the way that this goes. Yeah, he would owe her $195, and that would resolve all matters between the parties. That's my determination. I wish both sides well and good day.
Thank you for your time, Your Honor.
Thank you, Your Honor. Oh, I'm sorry, Your Honor. How should I pay her the funds?
In any way that is reasonable that you can keep a record, sir. If you have a cash app for it, do it that way. Whatever creates a record for you.
Okay. Thank you, sir.
Thank you, sir. That's it.
Just that it?
That's it.
Okay.